Hello, everyone. It's about noon Central Time, so I think we'll get started with the webinar. We want to thank everyone for taking time out of their busy day today to join us for today's webinar, which is entitled Insurance Recovery for Franchisors. We've got a lot to cover in a little under an hour, but before we dive in, I'd like to take some time to introduce our speakers. My name is Craig Miller, and I'm a partner in our franchise and product distribution group in our Minneapolis office. Also joining me is Kim Winter, a partner in our insurance recovery practice group, and Kim is located in our Kansas City office. And finally, Rick Kubler will also be wowing us with his thoughts and insight. Rick is also a partner in our insurance recovery group and is located in our Minneapolis office. Both Kim and Rick specialize in representing policyholders in a wide array of coverage disputes, so we're fortunate to have them with us. We encourage all of the attendees to submit questions to us through the group chat forum, and we'll do our best to answer those questions at the tail end of the presentation. With that said, let's get started. Kim, do you want to get us going?
Sure. Thank you, Craig. Welcome, everybody. So I'm going to kick it off with a quick overview of some of the things we want you to think about and some of the things we're going to be discussing today. Obviously, when you're thinking about your insurance coverage, you want to identify any unique risk that franchisors like yourselves may be facing. You want to actually review your policies in depth and make sure you've got appropriate coverage in place. We'll talk a little bit about procurement and negotiating terms, adding endorsements that you might need, and renewals of coverage. And then we'll talk a bit about reviewing different insurance requirements in the franchisor or franchisee agreements and making sure that you're in compliance with those. We'll talk about including appropriate additional insured requirements in your franchise agreements, and talk a little bit about considering all potential coverage that might be in play for a particular claim, including any older lost or missing policies, or maybe policies that were issued to a prior corporate entity. And then finally, we will end by going through a list of the top 10 common mistakes and pitfalls that we see clients making as they go through the claims process. So first, we're going to talk a little bit about insurance analysis.
I think everyone attending today's webinar probably understands that franchisors face unique and inherent risks. You know, there are healthcare risks, there are risks associated with injuries to customers or third parties from slip and falls. There's risks associated with injuries due to automobile accidents by franchisees' employees, and risks associated with loss of personal information or data, just to name a few. And these diverse risks that might be specific to a franchisor dictate the type of insurance coverage, obviously, that franchisor may need to obtain to protect itself, whether it's vicarious liability coverage or joint employer coverage, cybersecurity coverage, or automobile insurance. I think the important thing to remember here is that a franchisor's insurance coverage should be tailored to the individual needs of that franchisor and the industry in which they do business in. And you can see from the slide here that we provided a list of the types of policies that you should consider when thinking about the types of coverages your business might need. And so those are important. And I think as we move into the next slide, Kim, maybe you can just advise the attendees what policies from this list should a franchisor typically want to consider or review when it's sued directly by a franchisee.
Sure, thanks, Craig. Actually, in those situations, it's likely a franchise-specific E&O policy that might cover it, but all of these policies listed are pretty common policies that you likely want to have as part of your coverage profile. So, going to the next slide, just talking a little bit about policy reviews, and I know this is going to sound utterly ridiculous, but you actually should read your insurance policies. And if you don't want to do it, maybe make someone else under you do it. But I cannot tell you how many times I've had clients come to me and they really don't understand what they purchased as far as their coverage. So first piece of advice is just conduct a comprehensive analysis and look at the common industry and franchise specific risks that you might be facing, and just think about that as far as the terms of your policy, because coverage for millions and millions of dollars of defense costs alone sometimes can hinge on one or two words or a phrase here or there, or a particular endorsement in a policy. So make sure that you aren't just getting the bare requirements and whatever's required in your franchise agreement that you are required to place. Obviously, it's important to make sure you're meeting those requirements. But beyond that, policies are very widely. Different carriers offer different forms. There are all kinds of different endorsements you might want to think about getting, and you may even be able to specifically negotiate some specific policy terms. One thing to think about, if maybe you haven't reviewed your policies all that closely, or maybe you haven't done it recently and you're coming up on a renewal, keep in mind that typically carriers are pretty good about agreeing to extend a policy period for a couple of weeks or maybe 30 days or whatever you need. So if you are coming up on a renewal and you're thinking, maybe I should take a look at this and try to negotiate some different language, all is not lost if it's a quick renewal, because you can likely get it extended. And then just think about potential gaps that there might be in coverage, or on the opposite end of the spectrum, maybe you have some unnecessary or excessive coverage and you could save some premium dollars by cutting that out. Again, just make sure you're meeting your requirements and think about any specific risk that your franchisees may have as well.
Yeah, so one thing that franchisors are doing now more frequently is using a approved insurance supplier. And there are a number of advantages to that, but basically franchisors that have reached a certain size will often negotiate a group policy with, as I say, an approved supplier. Then the franchise agreement will state that the franchisee is required to purchase insurance from that supplier, and the requirements with respect to that coverage will then be included in the franchise agreement and the manual. And again, one of the biggest advantages to doing that is that since the franchisees already need to purchase insurance, franchisors will really have an opportunity to harness the group buying power of the brand and can use their large numbers to negotiate lower cost group insurance policies. And that can be a benefit not only to the franchisors in assuring consistency of coverage across the system, but also to the franchisees, because in theory then they'll have coverage that is well thought through by experts and will also hopefully receive a benefit in terms of reduced premium. There are some other advantages as well, and as I say, that would include consistency. There are some disadvantages, potentially. One of them is that by exerting a much greater degree of control and oversight of the insurance program, there could be an argument by a claimant against the franchisor vicariously that it has asserted too much control and that therefore it may have assumed some liability that it wouldn't ordinarily have had. But then the other concern, of course, is that if you essentially put your eggs all in one basket and you have just one carrier for the entire system, if an insolvency issue were to arise, that could be a big problem. Now, I think the risk of that is minimal so long as you've selected a carrier that has a very, very solid rating under AM Best or another similar service. So I don't see that as a significant downside. When selecting that carrier, and that's obviously a very important task, is to make sure that you get the right carrier. Of course, you look at competitiveness of premiums, but you want to also look at what collateral services they might offer. For example, are they available to help you track certificates of insurance and coverage requirements for franchisees? So you'll want to ask what other services they can provide. And then finally, carriers are not created equal when it comes to claims handling and customer service. And you should look around the industry and find out who has the best reputation for that currently and move in that direction.
Obviously, insurance is extremely important to protecting a franchisor's business operations, but franchisors need to realize also that it alone may be insufficient to indemnify a franchisor after a loss. So in the franchise context, we have these indemnification provisions in our franchise agreements which typically work together with the insurance provisions to ensure that a franchisor is protected from third-party claims that might arise from the acts and conduct of a franchisee, which are also known as vicarious liability claims. The indemnity provision becomes important in instances where a franchisee has failed to properly identify the franchisor as an additional insured under its policy. And that additional insured concept is something that Rick and Kim will talk about in a few minutes. But if no insurance exists because, for example, the franchisor has not been properly named as an additional insured, the franchisor can use the indemnity provision to reserve its right to seek reimbursement of its losses from a franchisee. As a kind of a real life example, we rely on the indemnity provisions when dealing with vicarious liability claims on behalf of several of our franchisor clients. So for example, in the hotel industry, if a customer slips and is injured at a franchisee's hotel and the customer mistakenly sues the franchisor, not understanding that the franchisee is an independent contractor, we immediately instruct the franchisor client that they should tender that defense of the action to the franchisee. And as part of that tender, we will remind the franchisee of the indemnity provisions in the franchise agreement in the event that they don't have coverage for the franchisor. And that's important because that usually creates an extra incentive for the franchisee to step in and defend the matter or resolve the matter with the plaintiff. So again, it's kind of the indemnity provisions and the additional insured provisions that Kim and Rick will now talk about are basically belts and suspenders that work together.
So as Craig mentioned, most franchise agreements can and should include a requirement the franchisees add the franchisor as an additional insured on their various liability policies. And as Craig mentioned, this does go hand in hand with the indemnity provision, but it is separate and distinct, and it's an important provision. You want to make sure that the franchise agreement has broad language about the additional insured requirements. And then you also want to ask for the policy, or at least the additional insured endorsement at the very least, just to make sure that you have verified your status as an additional insured under that policy, and to check the policy and make sure all the requirements are there. For example, you might want to make sure that the additional insured language includes a caveat that the additional insured coverage be both primary and non-contributory, which means if there is a claim that implicates both that policy and your own policy, rather than those two carriers pointing the finger at each other and maybe even sharing the risk, the additional insured coverage will pay first. So, it's not eroding your own retention on your policy or your limits on your policy, and it doesn't go on your claims history. Basically, you want the additional insured coverage to pay first and to not seek reimbursement or contribution from your own policies. So those are important provisions to keep in mind. And the benefits of having the additional insured status is, first of all, there's a duty to defend both the named insured and the additional insured. And even if there's a potential conflict between franchisor and franchisee, for example, the carrier typically has a duty to provide separate defense counsel to each. And so that's a good benefit of the additional insured provision. And also it gives you, as the additional insured, you have a direct action against that insurance company under that policy, as opposed to having to pursue the franchisee and then just hoping that they have coverage for it. You actually have a contractual right to pursue coverage yourself under that policy. And then, as I mentioned before, it just helps to save your own limits and your own claim experience so that hopefully your premiums don't go up under your own policies.
So Kim made the point that you want the right additional insured endorsement. And obviously, franchisors want the broadest possible AI coverage, including coverage for their own negligent acts or omissions. Insurers, by and large, want to try to limit the AI coverage to vicarious liability. So that would be liability not involving from your arising from your direct actions, but rather simply because you granted the franchise. And so I provided two examples, and I'll just really briefly talk about those. In the franchise context, there is an endorsement out there right now that's called grantor of franchise. And basically the language is that it applies only with respect to their liability as a grantor of a franchise to you. So what does that endorsement mean? Well, it could arguably mean just vicarious liability. The only coverage is because they have granted a franchise. And so there are other provisions that are much more beneficial that would talk about your liability, concurrent liability of the franchisee and the franchisor. And that's really the direction that you want to head. You want a situation where it's not limited to just vicarious liability. And you can work with your broker. There are a lot of forms out there, including those by the Insurance Service Office, that will give you that broader coverage. But it's important that you require your franchisees to carry the broadest possible AI endorsement. The other thing you should worry about in this regard is making sure that that endorsement doesn't limit coverage improperly. Oftentimes today, the ISO additional insured endorsements say that coverage is restricted only to the amounts available, or required, I should say, in the franchise agreement. Problem there is you may require $1 million in liability coverage, but if that additional insured, that franchisee has $5 million, and you've used that form, you will not receive benefit for the other $4 million. So here the workaround is to say in the franchise agreement, we require a minimum of the following limits, and then that should allow you to access that higher level of coverage with the franchisee. Next.
Hey, Rick, this is Craig. I have a question. Is it an issue and maybe you're going to address this, is it an issue if you've got a certificate of insurance that says that the franchisor is covered as an additional insured, but there's no endorsement that confirms that?
Well, yes, Craig. That can be a huge issue. It's not to say that you want a certificate of insurance, because clearly that's going to be required in all franchise agreements and manuals. But that certificate of insurance is not in and itself an insurance policy. So basically, if there's a discrepancy between the certificate of insurance and what that franchisee actually carries, the policy itself is going to govern. The only way you can, number one, confirm that you're actually an additional insured on that policy is to obtain a copy of the additional insured endorsement itself, or if the additional insured coverage is conferred through a provision in the policy called a broad form, you want to see that provision from the policy. Now, as a general matter, you always want to get a complete copy of the policy if you can. And I understand that can be difficult from an administrative standpoint, but now with being able to store these all electronically, it really is the best way to go. So the other thing to remember is that even after you obtain that initial policy, including the certificate of insurance, the declarations page, and best case, the entire policy, you're going to have renewals every year. And so it's not a one-time thing. You need to make sure that franchisee is submitting updated certificates of insurance and endorsements for each annual renewal period. Okay.
Rick,
go ahead. I'm sorry, Craig.
It's okay. One other question before you move to your next slide. Should a franchisor also consider as part of its practices to make sure that it's an additional insured on auto insurance as well for the franchisee?
Yes, and that's very typical. That can occur without cost, but to the extent that there's some sort of a delivery being made and automobiles are used in the franchise process at all, you should be included as an additional insured. And when you do that, I mean, the typical coverage for additional insured would be the comprehensive or commercial general liability, the automobile liability, and then the umbrella excess, which is very important. Often that's by following form, but that's where you're going to have your bigger limits, and that will sit over top of both the auto and the GL. All right, so COVID-19 insurance claims. We had planned to present this seminar several weeks ago, just about the time our office is closed, and I'm sure many of you encountered the same things. And so when we rescheduled this, we've basically, I wanted to bolt on a little bit of time to talk about COVID-19, although it's, again, it wasn't in the original program. So as a refresher, there's two types of insurance policies. Kim talked about those a bit earlier. There's third-party policies that cover liability claims brought against the insured. And then there's first-party policies, most typically a property policy, for example, or a crime policy that would provide coverage for the insured's own losses. So I'm going to focus primarily on the property coverage, the first-party coverage, but let me just speak briefly about third-party coverage because it is coming up right now in a lot of contexts too. So you may well run into this. And I should note too, this is franchisees and franchisors. It's not going to be unique to either, I don't think. So the first is comprehensive general liability. The easy example there is a customer gets exposed, for example, to COVID-19 at let's say a franchisee's restaurant. They assert a bodily injury claim. So it's already coming up. I just saw it today. There was a cruise ship example, and not in the franchise context, obviously, but a cruise ship line was sued because they should have warned the passengers before they came on, and they should have taken better measures. So you're going to see those claims coming in under CGL policies. Workers' comp, employer's liability. Obviously, the example here is employees exposed to COVID-19 at work. Okay, well, is that covered under workers' comp, the medical bills? Well, maybe, maybe not. It's all going to depend on whether the scope of the employment for that individual would be understood to include an exposure to a virus like this. If the risk is no greater than it would be for anyone on the street or the public, then it's not going to be a comp claim. They're going to have to look to their own private insurance. Now, to the extent that the employee brings a claim against the franchisee, for example, because they didn't give proper warnings, didn't do proper cleaning, didn't make the area safe, you'd see that under employer's liability. And I should say there was just a claim, I think the first one asserted this week relative to a Walmart brought by the estate of an employee that just passed away because of COVID-19. And then the final category I'll really briefly touch on is D&O, and that would fall into place where shareholders would bring a claim saying, hey, you didn't plan for this. You should have had contingency plans in place for whether it be carry out or other revenue sources, et cetera, and you didn't do it. And so the value of the stock's gone down, and we want to hold you, the C-suite, responsible. Okay? Now, for the most part, I'm thinking that these liability claims are really going to be the second wave. The liability things are going to come later. The first wave, though, will be first-party property claims, and we're seeing those now in spades across the board. I've listed here a number of types of coverage that can apply under first-party property. Obviously, the first one, well, property damage. I don't think we're seeing much of that here or any of that here. Nobody's claiming that a virus is destroying your building in any way. But the one that we're seeing most often right now is business income and extra expense. And that applies where you need to shut down your business for an extended period of time and you've lost income as a result of that. Or you incur extra expenses to try to get the business up and running again. Like in this case, let's say cleaning expenses associated with COVID-19. The next one, civil authority, that applies where, I think in pretty much all states now, with a few exceptions, there are executive orders saying that your businesses all need to shut down. With civil authority then, as long as that shutdown occurs under a covered cause of loss, you can get lost business income. Typically that's limited to around 30 days, and there's often an elimination period on the front end of between 24 hours and 3 days. But that's a coverage now that's receiving a lot of attention. And then real quickly, contingent business interruption. That occurs where you have like for instance with a franchise, if you have an up-gradient supplier that's providing meat, for some reason they can't distribute that meat to the stores for sale, that interrupts business, and so there's coverage for that. And then finally, leader property. If you were next to the Grand Canyon with your franchise, everybody knows they've closed down that and many other national parks now. That's going to have a huge impact on business, and that is what leader property relates to. So those are the main first-party coverages that might come into play. There are some others. Ingress and egress is under property policies as well. And then there are a few specialty forms out there, even one covering communicable diseases, which might have some impact here. Those are few and far between, though, and by and large, those would be for healthcare providers or somebody in that sort of field. Okay, so what are the requirements for one of these property claims? Well, under virtually every policy that I have ever seen, the coverage is only available where there's direct physical loss or damage to property resulting from a covered cause of loss. So the second part of that, covered cause of loss, is usually pretty good because they're often called all risk policies. So the key issue is, was there direct physical loss? So the carrier's immediate reaction on this thing across the country, and they've actually submitted this to some of the regulatory authorities so far that have asked for their position prospectively, is, well, look, a virus hasn't damaged the property at all. First of all, a lot of these closings have occurred without any evidence that the virus was even present in the building. But let's say that there was some virus present, that somebody got ill, or that you could prove the virus was actually present. Well, you clean it, and so you shouldn't need to shut down. That's the carrier's view of the world, but the other side of it would be, well, can direct physical loss be loss of use? I mean, isn't it the same thing? If you can't use your property, you can't be open for business. Isn't loss of use also a direct physical loss? And there's case law available on both sides of this in a variety of contexts that you can look at. But let's, suffice it to say that's the main battleground right now, and this is all going to play out in the courts. Civil authority, a thought here that might even make it broader than just the property damage claim would be, well, okay, I'm required to shut down for 30 days or more, depending on the executive order, and it's because of the virus. And most of these provisions say that the civil authority has to be from damage within, let's say 5 miles is a typical number within the location of the insured property. Well, there's clearly virus present within 5 miles of every building, and so again, if you can argue that the reason you're shutting down is because the presence of the virus, then it seems to me that you've got an argument on civil authority. And again, that's typically limited to 30 days, but 30 days of revenue can be pretty significant too. The thing to keep in mind here is that to prove coverage, the burden is on the policyholder. So the carrier is going to say, and the policy would support this, that you need to prove that direct physical loss. So if you're stuck with proving actual damage, that would be tough. You're going to need to argue that loss of use is sufficient to constitute direct physical loss. Real quickly, the main battlegrounds beyond the prima facie case for direct loss are the exclusions. There are pollution exclusions in almost every property policy today. They've been in there since the mid-'80s. Question, is this virus a contaminant? Because pollution exclusions don't typically include the word virus, in my experience. I've seen some that have, but most don't. Well, that's going to depend. I mean, the key questions are, do you treat a a provision, does the provision treat a virus like COVID-19 as a pollutant? And in that regard, does the pollution, does it have to be something like standard or well understood environmental pollution where you've had an oil spill, or can something like a virus that moves around and doesn't result from human creation and conduct, can that be a contaminant? Again, there's a lot of case law. It goes both ways. There are some that have talked about whether a virus is a contaminant and suggested it is, but there are a lot of others that say no. So then the final major battleground there is virus exclusions. And those were added about 15 years ago in response to the avian flu bird scare that was out there. And they pretty clearly state that there will be no coverage for any damage resulting from a virus. That's going to be really, really tough to get around, quite frankly. I can tell you they're not in every policy, though. I've seen a lot of them so far that do not have virus exclusions. So you want to check that very carefully. The other thing is that all is not lost if you have a virus exclusion. There are at least 6 state legislatures out there right now, including Massachusetts, Ohio, New Jersey, Pennsylvania, Louisiana, New York. They're all looking at legislation that would require carriers to cover, to some degree, business interruption losses, regardless of perhaps what that policy would say. Remains to be seen. Of course, the carriers will argue that there are all sorts of constitutional questions in play there, but that's out there as well.
Rick, a lot of our, or several of our franchisor clients are being told by their insurance companies or their brokers that they shouldn't bother bringing a business interruption claim for losses sustained as a result of the COVID-19 pandemic because such claims are excluded. Is that true? Is there any point in trying to bring a claim?
Yeah, absolutely. Again, the point that I raised early on here about what the main battleground is here, aside from the exclusionary language, is whether loss of use can constitute direct physical damage. And again, there are courts that support that. And I don't think that there's really any ability to debate the idea that if you have a shutdown order and you can't do business, you've essentially lost the use of that property, of the business that's insured. That was really the intent behind the whole thing. Now, I'm certainly not in a Pollyannish way suggesting that it's an easy battle or anything like that, but I mean, there really, from a downside standpoint, there really isn't a downside, in my view, to submitting the claim. And my recommendation would be, if you're suffering from these damages now, work with your broker, work with your counsel, develop the claim, submit it, keep excellent records of all your losses. That would be all the cleaning supplies you've used, compare your revenue to prior years. I mean, the main question is always, well, what did I make last year? What did I project for this year? The difference, in your view, would be COVID-19, and that's what you're going to ultimately submit to the carrier. But if you don't make a claim, obviously, you're never going to recover. And most property policies require you to submit notice of the claim as soon as practicable, and there may be deadlines for submitting that claim. For example, if it's not submitted before the end of a policy year and it was a known loss, you could have issues. And so I think the best advice is to sit down with your broker now, regardless of whether they tell you it's a dead bang winner or a dead bang loser. Get the claim submitted, document the loss, and then just don't take no for an answer immediately either. If you get a negative response out of the box, hold on to that and watch how things develop, because as I said, there are some legislative initiatives out there. The carriers may look for some silver lining for policyholders to pay or cover some part of this. So you don't know. But the bottom line is, Craig, I do recommend that well, in this case, franchisors that have been impacted by this really consider submitting a claim.
Yeah, I agree 100%. And I would add to that we have reviewed lots and lots and lots of these policies, and they're not cookie cutter. They're not standard form. I mean, Rick is correct that they do typically require some form of risk of direct physical loss of or damage to covered property, but these policies are really all over the board. And so we are hearing from a lot of policyholder clients that their brokers or insurance companies have responded and just said, nope, there's no coverage here, forget it. But you really do need to do a comprehensive review of your policies just to make sure that that's the case. I wouldn't take a no for an answer without a thorough review. So moving on, we want to talk a little bit about dealing with claims, and we've got top 10 mistakes that are made by franchisors just to think about. So first is overlooking potentially covered allegations in a complaint. Coverage may not be readily apparent at first glance when you get the complaint. And remember, all you're looking for to trigger the duty to defend is the potential for coverage. Typically, you just need one potentially covered claim. You know, one claim out of a 50-page complaint could do the trick. And then typically the insurer will have to defend the entire action. So that's why it's critical to really dissect the complaint. That means you don't want to rely on the headings or the titles of causes of action. The trigger for coverage might be buried somewhere in a paragraph seeking relief, for example. You want to assume only necessary bad elements. And what I mean by that is a claimant might claim intentional conduct throughout a complaint. Maybe they're hoping to get punitive damages, and so everything is alleged as being intentional or willful, and that's typically or often excluded under a policy. Well, when you boil down each cause of action to the necessary elements for liability to potentially attach, if malice or intent isn't required, then you still have the potential for a covered claim there. And then the duty to defend can attach. So something to keep in mind. And then also keep in mind that complaints are often sloppy or vague or inartfully written. And if that's the case, the policyholder gets the benefit of the doubt for purposes of the duty to defend. So I just want to give a couple of quick examples. Here are some copies of complaints where it wasn't apparent necessarily from looking at the complaint quickly, and insurers here said there was no coverage. So the first one was titled An Action for Injunctive Relief and Civil Penalties, which were not covered. But when you dive into the substantive allegations, you see that there's a statement alleging that the defendant was, quote, liable for certain costs and had caused certain monetary damages. And that was enough to trigger the coverage for the duty to defend. Also keep in mind that catch-all language at the end of most complaints where the claimant prays for, any and all other relief that the court deems just and proper or something like that. At least one court has found that in an otherwise uncovered, action for injunctive relief, that was enough to trigger the duty to defend. So keep that in mind. I'll talk quickly about the third one as well. This was a situation that we've seen a lot that involves intellectual property infringement claims. So this case, the third case that I have up here as an example, was primarily about patent infringement, which was not covered. But in a single paragraph that was hidden in a laundry list of other allegations, the complaint alleged that the defendant was, quote, spreading false rumors about the claimant's business. And because disparagement of another party's goods or services was a covered offense under coverage B of the defendant's policy, the general liability policy for personal and advertising injury, that alone was enough to trigger the insurer's duty to defend. So the lesson here is just don't dismiss the potential for coverage without really digging in and reviewing that complaint. The second common mistake that we see is ignoring extrinsic evidence. So basically any information that's outside of the complaint that could trigger coverage. Most jurisdictions require insurers to consider evidence that's presented to them that's not obvious from the complaint if that additional information will trigger the duty to defend. And keep in mind, this could be something immediately that you know about outside the complaint, or it could be things that come up later. Maybe the pleadings get amended. Maybe you've gotten a denial of coverage when you provided notice with the original complaint, but maybe a complaint gets amended and different allegations are added, or maybe something comes up in a deposition or in written discovery responses that could trigger coverage. So keep in mind that when that happens, you definitely want to forward those that information to the insured and reiterate your demand for a defense. Also remember, you may not even need to have a lawsuit filed to trigger coverage. Some policies are triggered by a claim, which can be written or even a verbal demand. So if the policy is triggered that way, it's not necessarily just the complaint that may trigger your coverage. Also, if the policy is only triggered by a quote-unquote suit, you still may be able to get pre-suit defense costs that were incurred in anticipation of the actual filing. Otherwise, it wouldn't be fair to the insured who's basically taking mitigating responses, appropriate preemptive steps, pre-filing that otherwise would be covered had the suit been filed a little bit earlier. So keep that in mind as well. So third is failing to identify all potentially applicable policies. You could easily have overlapping coverage for the same claim. There could be some allegations that trigger a general liability policy, for example, and then there might be other allegations in the same exact suit that might trigger your D&O policies. So make sure you put all carriers on notice. Make sure you're not leaving any coverage on the table if you need those limits. And also keep in mind there could be multiple policy periods that are involved depending on the allegations and how far back those allegations span. You may have multiple policy periods for the same type of coverage. And then if you need to, you can likely even get coverage when you don't have a complete copy of the policy. If the claim triggers coverage under a prior entity's policy, for example, or maybe some older policies that have just gone missing, or maybe they're incomplete, you still might be able to get coverage using secondary evidence of that policy. So to do that, you want to check general ledgers, maybe for specific premium payments that reference policies. You might talk to your current and even prior brokers. You might check with coverage counsel or defense counsel on any earlier claims that would have involved insurance coverage. There are lots of ways to track down missing and older policies that might be incomplete if needed. And then finally, you just want to make sure you think about any policies under which you are an additional insured. Like, don't forget that coverage is out there.
All right, mistake number 4, failing to properly notice insurance claims. We see this day in, day out. It's a real problem when it happens. It's a bigger problem on some policies than others, and we'll talk real briefly about that. But first, to the basics. And I believe in less is more when it comes to how you provide notice. You got to do it promptly, so you got to know what the rules are in your policy. Some policies say as soon as practicable. Some policies say before the end of the policy term. But regardless, you need to follow those requirements. You need to make sure that notice is sent to the right person. Usually there's not a person, obviously, but there's a contact address. Some policies say that notice is given to the broker. Bottom line is, know exactly what the requirements are and follow them. Always attach the demand letter, the complaint, whatever it is that's triggering coverage in your mind under the policy. I prefer that greatly to giving some sort of a long dissertation in a letter about what you think the claim is, because you're going to be stuck with that description forever, whereas the complaint or the demand letter, they speak for themselves. And then sometimes you may want to consider what we call a soft tender, which is, hey, we're giving you notice of this, but we don't want you to take any action right now. We'll be back in touch. You don't need to assign counsel, for example. You might do that where you've got another policy that's going to be providing a defense initially, and you just don't want to waive your rights under the one you're now providing notice for. There are reasons for that at times. And what are the benefits? Well, are obvious. I mean, the biggest benefit is you can lose the claim entirely if you don't provide proper notice. A couple of kinds of policies, I talked about this earlier. First-party policies, third-party policies. You know, with the first-party policies, again, by and large, notice it tends to be clearly within the policy period for a loss, and then some of them will say you need to submit a sworn proof of loss within 60 or 90 days. On the liability side, the claims-made policies, like your D&O policy, for example, that will require that claim be submitted as a condition preceding to coverage, meaning doesn't matter whether the carrier's prejudiced by getting that notice late or not. you will be out of luck in jurisdictions that enforce that, and there are a lot of them. Occurrence-based policies like your CGL policy, typically courts will say that the carrier has the burden to show that they were prejudiced by late notice. But again, don't rely on that. The key here is make notice, provide notice as soon as you can. When in doubt, provide notice. And then finally, one thing to note, a lot of times I'll talk with a client that will say, well, I want to hire you now. And then, within 3 weeks, you find out that they didn't tender, even though you recommended they do it, the coverage right away to the carrier. Problem there is almost no carrier will pay for your defense costs before the tender actually comes in. So be very cognizant of that as well. Get it tendered right away.
All right, another mistake that's commonly made by franchisors is not being prepared for the possibility of a declaratory judgment action by an insurance carrier. In some states, using Illinois as an example, the states require insurers to file a declaratory judgment action when there's a coverage dispute. And if they don't, they risk waiving their defenses. And in addition, some insurers, you might see that some carriers may file an action quickly after receiving a claim to select a forum favorable to the carrier. And so both of these situations may put the franchisor in the unwanted position of having to defend against the declaratory judgment action in an unfavorable forum. And so I think what the takeaway from this slide is to make sure that you as the franchisor get legal and counsel involved early when there's a coverage issue or a coverage dispute, and weigh your options so that you're thinking about, these types of declaratory judgment issues that might arise.
So 6 is not responding to coverage opinions from the insurance company. In particular, if a carrier agrees to defend subject to a reservation of rights to later deny, we often see clients just accepting those without responding to the reservation of rights letter. And the problem is you need to respond to those just to make sure you're protecting your own rights. We often see insurers attempting to reserve rights that don't exist under the policy, for example, like they may say they have the right to recoup defense costs. If the insured accepts the defense under that reservation without even a polite objection, then some courts have found that this has created a new contract. So even though it wasn't required in the policy, there's now a new agreement. So if the insured had objected to that, it would have protected those rights. So it's just important to respond to any correspondence you're getting from the carrier. And finally, I just want to mention when it comes to the insurer's request for information, obviously there's a duty to cooperate. You want to provide whatever information is reasonably necessary, but you don't necessarily have to respond to overbroad and onerous requests. Just something to keep in mind that if you are getting bombarded with requests for information, there is a reasonableness standard there, and it's perfectly fine to ask, what the basis is of the requirement, as opposed to just simply providing everything that they've asked for. And then 7, I want to talk a little bit about just blindly accepting when an insurance company attempts to appoint your defense counsel, and talk a little bit about panel counsel rates and billing guidelines. So even under a duty to defend policy, typically in most jurisdictions, if the insurance company has agreed to defend subject to a reservation of rights to later deny coverage, then most jurisdictions say that that creates a conflict of interest between the insurer and the insured. And because there's a conflict there, the insured should have the right to choose their own defense counsel, and the insurance company has to pay for that as long as the rates are reasonable. And there are instances where even if the insurance company has not reserved their rights, there still may be such a conflict. For example, if the policy limits are well below what the demand is or what the potential amount at risk is, that can also create a conflict that gives rise to the duty to provide independent counsel of the insured's choosing. And keep in mind, when insurance companies often seek to impose particular rates, and it's usually their panel counsel rates, unless there's something specific in the policy, typically the policies just require reasonable rates, which means, what's the market rate for this type of work in this particular area. So keep that in mind. And then also, even if there's no reservation, there's not really a conflict, but you have long-time, highly experienced counsel that understands the franchise issues and your business in particular, it just makes sense. It's in the best interest both for the franchisor and the insurer. Even if the hourly rates happen to be higher, typically, if you discuss these practical considerations with the insurer, they may understand that, hey, maybe we're paying a little bit more on hourly rates, but in the end, we're going to save a lot of money because of the expertise and because there's no getting up to speed time. And then finally, I would just say, make sure you watch billing guidelines. Often they're perfectly fine, but there may be a few things in there here or there that, attempt to impede counsel's legal judgment, or maybe they invade privilege. So if you need to object to the billing guidelines, make sure you do that.
Okay, mistake 8, failing to involve carriers in settlement opportunities. Being cognizant of time and wanting to take questions here, let me just say on this one, I think the key takeaway on this is every policy includes what's called a voluntary payment provision. If you get a demand letter from a claimant, you go ahead and you pay that, it seems reasonable to you, and then you turn around and say, hey, we had a short amount of time, carrier, we want you to cover this. Obviously, it fell within coverage. Even if it would have been fully covered, the carrier is going to say you violated the cooperation clause, the voluntary payment provision it's often called, and we're denying the claim on that basis alone. And, like failing to give timely notice, in many occasions, that's a condition preceding to them having to indemnify you. So you need to involve the carrier in settlement negotiations or you'll lose the claim. The other thing to keep in mind here, and I think this is important too, is that you need to position yourself to make sure that carrier will respond to a demand, a settlement demand within the policy limits. If you structure that right, working with defense counsel and laying it all out in writing, and then the carrier refuses to put up that policy limit when the defense counsel has said exposure is way in excess of policy limits here, and it ultimately turns out judgment comes in and you get hit for something way above limits, you can get that carrier for bad faith and you can actually blow through the limit. So that's a very important thing to keep in mind as well. Next. A related concern, and our mistake number 9, is failing to properly document the settlement, not only with the plaintiff or the claimant in the case, but also with the insurers. Real risk here is that you reach a deal, the carrier makes its contribution, and then turns around and tries to sue you or perhaps your customer or some other related entity for subrogation or contribution to that. You don't want that to happen. So what you want is a written, clear agreement describing what the carrier is going to contribute, the scope of the release, and here you've got to watch out for a claim release, which only involves the thing that you just settled, or a policy release. Carriers love to get a policy release and take their paper back. You've got to be cognizant of that. And then finally, make sure that if there are remaining claims that could potentially occur, like for instance in a class action situation where that class has not yet been certified, you've been sued, you reach a deal, you want to make sure that you preserve the right to come back to that carrier in the event that a new class action is brought and there's an attempt to certify there. And then finally, you need to keep your eye on excess insurance. If you settle with a primary carrier for under their limit, the excess carrier in all cases almost is going to turn around and say, hey, we don't have to pick up the defense now or pay any money until you satisfy the delta. So keep that in mind as well.
And then our last mistake before we take some questions is just wrongfully assuming that communications are privileged. Often, we have clients that are communicating with their brokers, or maybe they're communicating with their carriers, and those may not be privileged depending on the circumstances. Even if you have your counsel involved in some jurisdictions, having the broker also involved breaks that attorney-client privilege. And then when it comes to communicating with carriers, as far as providing a bunch of information, we see this a lot where, excess carriers have requested lots of sensitive information. And in many jurisdictions, the only privilege exists when the carrier is actually actively defending a lawsuit. So if this is pre-suit, or if the excess carrier is not defending, it's the primary carrier that's defending, you just want to be careful about what you provide as far as any sensitive information, because the last thing you want is is for the claimant to get access to this information in discovery. So we recommend using confidentiality agreements. Those are not ironclad, but at least that provides a basis to argue that you intended to keep all of this information privileged. And then when in doubt, just pick up the phone. Don't send anything in writing that you wouldn't want the claimant to get their hands on.
Great. Thanks, Kim. Thanks, Rick. And we've got about 5 minutes or so left for questions. And I do note that through the chat forum, we've got a few here that have been posted. So we'll just run through these questions in the order that they were received. Rick, I think the first one's probably directed toward you because I think you touched on this already, but one of the attendees is interested in knowing if the virus exclusion is a normal term.
It appears in some policies. I can tell you that I've looked at a lot of them already. As Kim said, we're looking at lots of insurance policies. Some have them, but many of them do not. I'll just say our firm's policy, for example, does not have a virus exclusion. I'd like to take some credit and say I analyzed that line for line on the last renewal and found it and struck it or something, but I can't. It doesn't happen to be in there. But you need to review it. There's not a rule of thumb. It may be there, it may not.
Yeah, and keep in mind that it's the insurer's burden to prove that any exclusion applies. So even, depending on, I've seen virus exclusions all over the board. These are not standard form. So depending on the specific exclusion and your particular circumstances, there may be an argument, that the insurance company won't be able to meet their burden with regard to a virus exclusion. So I would just keep that in mind.
I think that's an excellent point, Kim, and if it didn't come out clearly when we talked about this is very, very policy specific, and there is not one standard form that everyone has out there. There are an innumerable amount of them. There are variations that could be the difference between coverage and not coverage, so just don't assume that there's one form and that these are either covered or not covered.
Another attendee has asked, and Rick, you touched on this, what are the pros or cons on using an approved broker versus approved insurance supplier? That's one question. And if we do an approved insurance supplier, what is the risk to the franchisor that the franchisee doesn't have adequate insurance in the event of a suit?
Yeah, okay, so those are excellent questions. First, on supplier being an insurance company versus having sort of an approved broker, if you will, the broker's going to be involved regardless. As the franchisor, you're going to want to get your competent, experienced broker to help you canvass the market and request proposals and develop that program. So in my mind, you find a supplier because that's going to ensure the forms are exactly the same. I mean, that's what you really want, is that continuity throughout your system, rather than just coming up. What you have now basically is a set of limits and types of coverages that you want. But the benefit you get from having, the one supplier, I think, is that it's exactly the same form. And I think there's benefit to that. Now, on the question that you asked about, well, what if we take the step and we identify all this? I do recommend, sort of as a rule of thumb, that franchise agreements include a provision that says the fact that we've identified these minimum limits does not mean or does not excuse you from looking and being responsible as the franchisee for procuring whatever insurance is required. So in other words, and you can talk about enforceability of it, but at least that's basically notice to that franchisee that while you've set these limits and you've set these insurance requirements, you are not assuming responsibility for whether those are sufficient or not. You need to make that very clear in your agreements if you haven't already.
I noticed that we're getting close to the 1 o'clock witching hour. I think both Rick and Kim and myself are willing to sit on this webinar for another 5 minutes or so to get through the remaining questions. So if you need to leave, understood, but if you want to stay put for a few more minutes while we try to get through these messages, that's great too. Next question, and I'm not quite sure I understand it, but what happens when the insurance is sending directly the exclusion of virus without even wanting to get the claim?
I think the point he's trying to make is, like what I was saying before, there are a lot of insurance companies just immediately citing to, virus exclusion and sending out blanket notices to policyholders, basically saying, don't bother providing a claim. And like I said before, I would not take a simple no for an answer. I would absolutely file the claim. And again, keep in mind that any exclusion is going to be the insurance company's burden to prove. So I would absolutely make the claim.
Okay.
Well, right. And so as I understood the question, the claim was already made, but instead of sort of a full analysis and requesting documentation and explanation, et cetera, the carrier just says, oh, virus exclusion, you lose. Well, I think the outcome is still the same from our perspective, which is you don't leave it at that. You need to carefully review that exclusionary language. You look for some of the coverages within the policy that it might not apply to. And then, on a broader spectrum, and we didn't talk about this, you need to look at every single one of your policies here. You might have a pollution legal liability policy, for example, that would expressly cover cleanup costs, and some of them have business interruption coverage to them. So, we could spend, hours and hours presenting on the COVID-19 insurance situation. We only had a few minutes for it today, but don't just take no for an answer out of the box.
One thing I did want to mention before people start jumping off, because somebody did ask, will the attendees receive a link to the recording of this webinar? The answer to that is yes. If you've attended or signed up for the webinar today, you will receive an email tomorrow with a link to a recording of the webinar. One of our other attendees, I think wisely and aptly notes that the one thing about the triggering language that you and Rick and Kim spoke about before is that it works both ways. That if the franchisor is, the claimant or the plaintiff and initiating the lawsuit, they should be careful to limit allegations to necessary claims so that they don't inadvertently trigger the franchisee's policies for purposes of their defense. I don't know, Kim or Rick, if you got any comments on that.
Yeah, I will comment on that's an excellent point. My discussion about when to give notice, and I think that the notice discussion on that Kim had as well was focused on you are receiving this notice. So rather than, but you're right, there's two sides of it, and policies are different. Like on a D&O type policy, a suit is not required. A claim can come just in the form of a written or even oral demand. In some cases, policies will trigger coverage with an oral demand, but typically it's a demand for monetary or non-monetary relief in some way at a minimum. So you can usually thoughtfully figure out how to convey those messages. If you don't want that coverage triggered, you need to think that through, look around that corner before you actually make that demand or make that call to the adverse party. So you're right, that is a very important consideration.
Next question is, does a virus or bacteria exclusion trump civil authority coverage?
Typical lawyer speak, it depends. I've seen very broad virus and bacteria exclusions that apply to every possible claim arising out of it, no matter, even if there's a concurrent causation that would be covered. And I've seen narrower. So sometimes civil authority, for example, will apply, and you simply have to show that there was some sort of direct physical loss somewhere near you that caused this civil authority. So again, the policies are really all over the place, and I would advise you to check yours carefully to see if there's an argument.
Well, that's exactly right. Quite frankly, though, there's not a distinction in terms of the exclusionary language, I don't think, between just straight business interruption coverage and coverage for civil authority. They both have sort of the same triggering requirement. It may be easier to get to civil authority because it doesn't have to be damage that exists on your property. It can be within the vicinity of your property. That's clearly very helpful. But once you get past the coverage grant and you've made the argument that you have it or you don't, then you shift to the exclusions. And so, I don't know if there's a difference there. The bottom line, though, is you still do have to review and see whether that exclusion is going to apply. And as a general matter, courts review exclusions very narrowly. These are contracts of adhesion, meaning these carriers are writing these things and they're contracts of adhesion, and so courts look at them and say, what were the reasonable expectations of the insured? If there's more than one reading of this provision, we're going to try to read it in favor of coverage. So you have to keep that in mind, that there's a difference between exclusionary language and how courts apply it, and then the grant of coverage on the front end, which is really the policyholder's burden.
Okay, two final questions, and then we'll conclude the webinar. One is, and I'm not even sure we're in a position to answer this, but an attendee wants to know if we're aware of a national insurer who's better to consider as an improved insurance supplier.
Unfortunately, I don't think our general counsel would appreciate us putting that info out there, so we try to refrain from that. I will tell you, I think we're probably suing most of them, so I don't know how to answer that one.
Look, next question.
That's a tough one, but I think, again, I'll go back to the broker on this part of it. While there's things that your brokers are great at a number of things and lawyers do other things, but from a broker standpoint, your broker should be able to identify the insurance suppliers, the carriers out there that really have developed and worked hard to have this expertise in this area and have designed programs that, center around franchise-specific issues. And, it's a beauty contest at that point, it seems to me. But I agree with Kim. I can't identify for you, well, this one's better than others.
Yeah, that's more a question for the broker.
Yeah.
All right, last question. Under civil authority, does the order restricting access need to be complete? For example, for a restaurant, if it's limited to drive-through only, is that a restriction?
So we started to talk about, and one of the slides actually has in it, and though we didn't get to it time-wise, about whether you got to have a complete shutdown or not of your business in order to get that business interruption coverage. And, policies will differ in their language in that regard. But certainly I've had situations where a carrier has said, look, you didn't have a complete shutdown. Typically, though, they'll step back from that because there's also a duty to mitigate under the policy. So, an easy answer for an insured is, well, I had to shut down completely. And as a result of that, you need to pay. But then from the carrier's perspective, they're saying, well, what if you could have been generating some revenue? That reduces the loss. And so usually with that sort of a situation, the carrier doesn't stand too hard on that need to be a complete shutdown situation, that a significant reduction as part of a covered cause of loss could be enough to trigger the coverage.
I agree, and I would just add that I've seen many, many, many policies that when it comes to civil authority and ingress, egress, and some of those other types of business interruption, it will simply require a impaired access, not necessarily a complete shutdown. So you really need to look at your policy to determine what the language says.
Okay, great. I think that concludes the webinar. We really appreciate everybody's attendance and for the thoughtful questions as well. As I indicated earlier, those that had signed up for the webinar, today's webinar, will receive an email tomorrow with a link to a recording of the webinar. And in the meantime, if you have any questions or we weren't able to address a question you might have, please feel free to contact any one of us. Our contact information can be found at the beginning of our PowerPoint slides. Thank you.